And we are live on Who Wrote That Up For You. Today is Thursday, October 27th, 2022. I'm Sonia Ebron, a co-founder at Courtroom 5.
And I'm Deborah Sloan, the other co founder at Courtroom 5.
We've got a marvelous show lined up for you today. In a few moments, we hope to speak with Doug Noll. He is a court mediator, calls himself a peacemaker. And so we'll hear his perspective on how to make peace in the very difficult litigation environment. A little later in the show, we will speak with Kenn Goldblatt. Kenn is the author of The Pro Se Litigant's Civil Litigation Handbook, available at fine bookstores everywhere. And we'll get his background and experience as a pro se litigant and his advice for others dealing with that difficult situation. Before we get there, Deborah, what is on your mind today? What is our issue of the day?
I want to kind of touch on the legal process in the context of kind of a convoluted everyday situation. Anne Elizabeth was awarded a free house by an organization in Detroit called Writer House, which was giving free houses to writers. And she thought, oh, cool, I have this free house. It's a nice house. And she settled in. She had the roof replaced and some other minor repairs and enjoyed her house for about 4 years. And then when she got a job in another state, she tried to sell the house, but learned that she did not own the deed to the house. Someone else did. So she went ahead and she sued for a quiet title. So the person whose name was on the deed, a woman named Tamika, she found out that her house was being sold when she received the court papers from Anne Elizabeth. She'd bought the house several years before for just $700 and for whatever back taxes there were. At that time in Detroit, there was of course, that housing crash, and they were selling houses for back taxes, basically. And so she and her husband and their kids, they lived in an apartment while they worked, while some work was being done on the house. And they put tons of money into the house, and they started to pay the back taxes until they got sick, and basically they stopped visiting the house, but they still felt they owned the house. But 5 years after she bought the house, Wayne County sold it for $5,000 to write a house. According to her, she never received any tax notices, she never received any foreclosure closure notices or anything like that. The story goes on all the way back to a resident from Bangladesh having bought the house and defaulted on the mortgage and abandoned it at the peak of the financial collapse. So after Tamika bought the house in 2010, the house technically remained in her name. But that didn't stop Wayne County from selling it out from under her without telling her why. So now, roughly 20 families facing foreclosure have sued the county in federal court, alleging that the foreclosures were illegal because owners didn't receive notices and believed they had more time to pay taxes and to save their properties. The thing is that Michigan is a non-judicial foreclosure state, which means that you don't have to go through the court to for somebody to lose their house in foreclosure. And so it turns out that these got to court because there's some shady dealings. I just feel like that it was that Wayne County had a big responsibility to basically keep this out of the court by doing the right thing, and they actually didn't. They just started just selling and selling and selling and selling until it comes to this now, where they're now being sued.
That is an amazing story. I mean, who benefits from that practice of selling houses, without properly informing the presumed title holder? It's bizarre. It reminds me of these cities that have a low tax base. They've decided not to tax the wealthier people, in their territories, and go after more vulnerable people on schemes like this, whether it is parking tickets or traffic stops and that sort of thing, in order to create revenue, in order to earn revenue, because they're not properly taxing their citizens. And I'm just wondering if that's the case here in Wayne County. That is so that is so unfortunate. This is a big deal. You're talking about somebody's home. You know,
Exactly. Exactly.
I think you said somebody put a roof on, and I mean they are acting like
Mm-hmm.
owners, right? With the exception of perhaps missing a tax bill or something like that, which is really easy to do.
Right.
Particularly
Right.
when you aren't being notified that you've got taxes due or late taxes and that sort of thing. That's that is really extraordinary. Well, I'm really glad to hear that folks have gone to federal court on this. I don't imagine that Wayne County is unique in doing this sort of thing, but there's so many. It seems to me, we hear every week of some city doing something crazy like this to abuse their citizens.
And it's important to note that people in non-judicial foreclosure states, uh, they think that this would that the foreclosure case will never get to court, but that's not really what that means. It just means that they can have their house taken without going to court, but it can actually get to court, eventually, like these have. So it's important that people find out how, if you have to get to court regarding your house in a non-judicial state, to go ahead and find that out, because there is a way you can do that.
It's interesting, and I do just want to share with folks who aren't aware that about half the states are judicial states where your mortgager, mortgagee, whoever has the mortgage, whoever is paying, right? Whoever the homeowner is paying has to actually sue you to foreclose on the property. But the other half, they don't. They just have to notify you that the house is being foreclosed, and you then have to file suit to stop that, right? In these so-called non-judicial states, and so they're called non-judicial, I think, because the person who owns the mortgage can simply notify you that, hey, you gotta go.
Yeah.
And you have the burden then of stopping that through a court order. So that is just that is very difficult. There should be some uniform standard, I think, when you're talking about property in this way. We have I think it's the UCC, the Uniform Commercial Code, there, which is a federal code on just handling all kinds of properties, whether they're real property or other kinds of properties. And it seems to me that that's an opportunity to federalize some of these standards, right? So that no matter where you are, I mean, it shouldn't matter uh, where you are in the country, the way you handle something like your home and the ownership
Yeah,
of it. That should be standardized in some way.
I think so. I think so too.
Absolutely. Well, thank you for bringing that to our attention, Deborah. Who Wrote That Up for You is sponsored by Courtroom 5. At Courtroom 5, we believe the courts belong to the people, in particular to the people who use them. And we, the people, are coming to claim our courts. So if you are in court without a lawyer, or if you need to sue someone and can't find a lawyer to represent you, get yourself over to courtroom5.com. Try a limited version of our services for free, and we hope to provide some relief for you there. At this time, I'd like to welcome onto the show Mr. Kenn Goldblatt. Mr. Goldblatt, thank you for joining. Who Wrote That Up for You?
Thank you. I appreciate being here.
It's my pleasure to have you. And so I just wanted to let our audience know that you are the author of the Pro Se Litigants Civil Litigation Handbook. Mr. Goldblatt, how did you get involved? How did you become knowledgeable on that subject? How did you get involved initially in civil litigation?
Well, it's kind of a long story. I went to the aid of a friend and mentor who was in a probate suit, and I got sued for my trouble for doing it, which only goes to show you that no good deed goes unpunished. And so from there, I knew that I didn't have enough money to pay a lawyer to do all the things that needed to be done in that kind of lawsuit. So I found a lawyer that would let me do the research and the writing as much as possible, and he'd just oversee it. So, of course, at first I wasn't very good at it, but as I got better, he marked it up less and less, and I finally wound up becoming a certified paralegal, and I worked for him for 20 years after that until he died.
That is a significant amount of experience as a paralegal and just dealing with the sorts of cases you must have seen. Well, what made you decide to write the Civil Litigants Handbook here?
Well, again, that's probably a longer story than you've got time for. But basically what happened is as I progressed through the different stages of doing the litigation things that I was doing as a paralegal, then a trial paralegal, and as an advocate under the Americans with Disabilities Act, Amendments Act of 2009, I kept meeting people that were trying to proceed on their own and just didn't have a clue about how to do it. And the more that I did that, the more I found out judges hated them because they didn't really know what they were doing. And as I counseled them and explained to them what was happening, I realized that there was probably a book there that needed to be written. So I did the handbook because of that.
Fantastic. I'm
That's
so
great.
glad you did. And so, assuming I knew nothing about civil litigation, this was my first time in court, I found myself sued, and I purchased your book. What would I find? How would it help me?
Well, it goes step by step from the filing of the lawsuit initially through each stage of litigation that includes doing the discovery, filing motions, and then going to hearings before the judge, speaking at those hearings, and it's got an appendix of what the motion should look like and what motion should be provided and be filed. So it gives a pretty thoroughgoing understanding of what you have to do in a lawsuit from start to finish.
Fantastic. And as you know, that information isn't always readily available, or it's available in pieces all over the place and sort of hard to find in one place. Have you heard from readers of your book about how it's been helpful to them?
Oh, yeah. Every once in a while, I have somebody call me and say, I've got this problem. Can you answer these questions? Or in some cases, can you help me? And in one case, as a matter of fact, it's come full circle in my life, a guy who's involved in a case that's basically a dispute with his family over a probate case. Came to me and said, gee, I don't know, what I need to do about this. Can you help me? And so now I've been helping him. In fact, I got a call from him just this afternoon, getting ready for a hearing. So those sorts of things. And then I've become a litigation manager for people who need more help than that, where they hire me to simply, hold their hand and go through the different hearings with them and tell them what they need to do in terms of filing, or help them file things, or read their filings and make suggestions about how they can correct themselves.
Understood. The book was published, I understand, in 2016. Have you developed any plans to maybe update it or release a second edition?
Not at this time. I will be probably doing a second edition at some point, but as you know, litigation moves pretty slowly, and so there haven't been any real requirements to update that per se. And the process hasn't changed at all since the time I wrote it, and it's likely that it probably won't change much until I get ready to do a second edition.
Fantastic, fantastic. Mr. Goldblatt, I'm sharing on the screen the title of your book, and I understand it's available on Amazon, Barnes and Noble, and Author House as well. Where else can people find you online if they'd like to reach out?
Well, basically, most people reach me through email and n.goldblatt@gmail.com. And other than that, they can basically dial me on the telephone, which is how I get most of my referrals. Is people just call me and say, "Are you the guy who wrote the book?" And I say, "Yes, I am." And they say, "Well, gee, I got this problem. Will you help me?" So I wind up talking to them for a while, and then that either leads to their immediate problem, or they say, "Well, help me on a longer term basis," and then either they hire me or they retain me in some way to keep talking to them.
I understand. I understand. Mr. Goldblatt, thank you so much for your book and for sharing your wisdom here on Who Wrote That Up for You. We'll stay in touch and we'll have you back very soon. Thank you so much, sir.
I
Thank
appreciate
you.
it. Thank you for having me.
All right. It's great.
Deborah, who won yesterday's quiz, if anyone? And, what do you have teed up for us tomorrow?
Okay, yesterday's quiz I thought was pretty hard, but we actually have a winner. Um, the question was discovery in the lawsuit that Kelsey filed against Dr. Fig Newton is coming to a close. Kelsey is convinced that he has evidence to prove all the elements of his claim. What essential things should Kelsey do now to have the best chance of getting summary judgment as a matter of law? And the answer is Kelsey should move to strike each and every one of Dr. Newton's affirmative defenses. And I've focused on affirmative defenses a lot and striking them because sometimes we, as pro se litigants, kind of forget some of the details of that. And the winner is Oscar R.
Congratulations to Oscar there. And that was a trick. I never would have
It
come
was
up with that
not a
answer.
trick question.
It's a trick question. We've got some real mind readers out here. So thank you to Oscar for getting that.
Okay, in today's quiz, fill in the blank. A successful blank ends the case before trial by proving there are no relevant facts in dispute and that the movement should prevail as a matter of law. Is it a counterclaim, a motion to dispute the facts, a motion for summary judgment, or a motion to dismiss? If you want to participate in today's quiz, send your responses to quiz@courtroom5.com.
I'm looking forward to seeing the answers to those. Fantastic. All right. At this time, it's my pleasure to welcome onto the show Doug Noll. Doug is a mediator and a peacemaker, as he bills himself. And so, Doug, thank you so much for joining us on Who Wrote That Up for You.
Well, it's great to be here, ladies.
Fantastic. Doug, give our audience, if you would, some background and how you came to become a mediator.
Right. I was a trial lawyer for 22 years, a civil litigator, tried hundreds of trials, bench trials, jury trials, arbitrations. Um, and through a series of events that started in the mid-1980s, eventually I concluded that being a trial lawyer was not my calling. So in mid-career, I went back to school and earned my master's degree in peacemaking and conflict studies. And my partners and I didn't agree about my change of course, so I gave 1 week's notice and left $10 million on the table in my law firm and walked out and started my own peacemaking practice in 2000.
You have got to be serious about peace to do that.
I am. Very much so.
Thank you for that choice. Then, well, let me ask you. When you're dealing with people in litigation, it's a battlefield. It is oftentimes a really ugly situation to find yourself in, and particularly when you have self-represented litigants, as the courts are flooded with these days. There can be emotions because these folks are directly involved in the facts of the case, from jubilation at a win to just terror to anger, just across the board sorts of emotions you must witness there. how do you go about calming someone down, reducing the temperature, if you will, of litigation? How do you address someone who's caught up in their emotions in that way?
I've developed a skill that is extremely powerful for doing just that, and it's called affect labeling. And basically, when you're confronted by an angry person, you ignore the words, read their emotions, and reflect back their emotions with a simple you statement. So I would say something like, Sonia, you're really angry, you're pissed off, you're frustrated, you feel completely unappreciated and unsupported, nobody's listening to you, you feel like you're being treated really unfairly, and you're anxious and worried and concerned, and you're sad and distressed and upset, and you feel completely abandoned and betrayed. By me, yeah, you're smiling. How did that go for you?
I tend to ask the questions, but I'll answer this one. I would want to choke you if you said that if I was angry, right? I would reach
Actually,
out. Yeah.
I wouldn't.
it's just the opposite. It's just the opposite. You would think that when you tell somebody how they feel, that they would feel like you're being rude or impertinent or patronizing. It's exactly the opposite. The brain science shows that when you do this, you deactivate the emotional centers of the brain and activate the part of the brain called the ventrolateral prefrontal cortex, which is the executive function of our brain. So there's hard science to show why this works. And it's counterintuitive and it's counternormative. It's counterintuitive because we would never think about telling somebody how they feel. And it's counternormative because we are raised to say that emotions are bad, they're irrational, they make us weak. And therefore, the idea of telling somebody how they feel would be rude. And it turns out that all of that conventional wisdom is wrong.
That's interesting. And so you've practiced this and you've seen people. What is the response when you call someone's emotions?
People calm down almost immediately, usually within 90 seconds, and they're deeply grateful because they say, wow, you really get me. You really understand it. I was doing a difficult conversation earlier today between an adult daughter and her mother, and each of them said, wow, you told me how I feel better than I could ever express it for myself. And they were in deep gratitude that I allowed them to have a conversation with each other that they had to have. And what I did was create the safe container, and by labeling their emotions, kept them all under control.
And what is the name again of this technique?
It's called affect labeling.
Affect labeling. Fantastic. That's extraordinary. I really appreciate you sharing that. It is, as I think about it, not so counterintuitive, because when people have emotions, they are expressing that they need to be seen. Right, that it's not the words, right. It's not the facts. It
That's
is
right. They have a deep need. They have a deep need to be validated.
Yeah,
that's
exactly.
Right. And this will work every single time. I'd like to say though that you were talking about litigation. I'm not sure I agree with the answer to your quiz. I don't think I'd make a motion to strike affirmative defenses. What I would do is send out a set of requests for admissions and have them admit every fact that supports my case. Because at least under California law, if you deny an admission that is later proved to be true, you have to pay attorney's fees and costs. And if they make their admission, then the court has to take judicial notice of that, and it becomes fair. I won a $12 million lawsuit against a very large insurance company because I did just exactly that many years ago.
I love that. Thank you.
That is
but my advice to pro se, I'm on the arbitration panel of the American Arbitration Association, and I do a lot of pro se arbitrations where one side is not represented by counsel. And I would say that the most important thing you can do as a pro se litigant is get into mediation as quickly as possible. Mediation is an informal process to settle lawsuits. It is extremely effective. 95% of all cases that get into mediation settle. And you save yourself a lot of grief and effort if you get into mediation. And the thing is, here's something that many people, not even lawyers, get this, but the court system is not about justice. Justice is the last thing the court system is all about. What the court system is about is decision making. Who owes who what, how much money? It's just a decision making system. And it doesn't guarantee justice. It doesn't guarantee any kind of justice. And people yet think that liberty and justice for all, we're going to get justice in the courtroom. No, you're not going to be vindicated. You're not going to be validated. You're not going to be heard. The 6 needs of justice will never be met. And so your best bet, if you're a pro se litigant, is if you have to file the case, so you're a plaintiff, invite mediation as soon as possible. If you're the defendant, invite mediation as soon as possible. Get it into the hands of a mediator, and save yourself tens of thousands of dollars and a lot of heartache and grief, and get the thing over with.
Let me ask you
Yeah, I would just say lawsuits are salvage operations, and you
yeah,
want to salvage as much as you can, as fast as you can.
absolutely. Isn't it true though that if you settle early in the case, you're going to get a lower settlement award than if you wait and fight it out a little bit and drive a bigger settlement?
Not necessarily. It depends on how well prepared you are. If you have done your homework and you've prepared your case thoroughly before you file your lawsuit, which you should do,
Yeah.
then you can go to if you're the plaintiff, you can send a letter to the defendant and said, here's my case, tell me how I'm going to lose. And oftentimes that will induce people to go to mediation. And in mediation, you don't have to accept what's offered. If the defendant doesn't offer enough money, you can always refuse it and come back and mediate another day later on in the case.
Yeah.
So just because you mediate once doesn't mean you can't mediate multiple times during the course of the litigation as things change. But do it early and save yourself a lot of grief and heartache.
That is great. And so you've been a mediator for a number of years there.
Yeah.
Do you find self-represented people taking your advice to jump into mediation as soon as possible?
No, because typically self-represented people are angry and they want vengeance. And they want to exact pain and fury on the other side because they feel like they've been dealt this deep and abiding injustice. And so talking about settlement is like talking to the devil.
Yeah.
And that is very typical. And my advice is overcome all of that. You're not going to get vengeance no matter what happens. Even if you win your lawsuit, it's going to be a shallow because it costs you so much to get that victory. And even if you win, there's no guarantee you're going to be able to collect on your judgment. So lawsuits are a really good way to waste a lot of time and money. That's why I left.
Yeah. No doubt about it. Understood. I appreciate that wisdom. Let me also ask then, are there ways outside of mediation to settle the case? And what do you recommend for self-represented litigants who find themselves in that situation, that is not able to take advantage of a mediation process?
The mediation is nothing more than a facilitated negotiation. And so if you can learn how to negotiate a legal settlement, then you should do that. And I actually am the creator of Negotiation Mastery for the Legal Professional. It's the most advanced online legal negotiation course that's out there. And if you're a pro se litigant in a fairly large case and you need to learn how to negotiate, that's the course you need to take, because it'll give you, I can guarantee you'll know more about negotiation than 99% of the lawyers out there. Most lawyers are very poor negotiators. And you can, just because they're poor negotiators doesn't mean you as a non-lawyer have to be a poor negotiator. You can learn how to negotiate these things and start negotiating right away. It may be, the problem, it depends on who's on the other side, whether the lawyer is being, is with an insurance company or is a defense firm or is just a general civil litigator. They have conflicted interests. One is to generate their billable hours, and two is to resolve the cases fair and equitably for their clients as quickly as possible. So they're conflicted. Most lawyers are pretty ethical, so they will invite an early settlement discussion, and maybe it doesn't go anywhere, but at least you learn where the differences are, and then that helps you develop your case as you go into discovery. You can learn a lot in early mediation, about what the other side is thinking and why they're resisting paying. Gives you a huge amount of insight.
That's fantastic. That is extraordinary wisdom. Really grateful for that. Doug, I'm going to share your website with our users on the screen here. But where else? And that's dougnoll.com.
Right.
Where else can our viewers and listeners find you online?
I'm everywhere. If they're interested in the legal negotiation course, that's called legalpronegotiator.com. If they're interested in my mediation and arbitration practice, that's nollassociates.com. And I'm active on social media. I have YouTube channels. I'm very active on LinkedIn. Facebook, Instagram. I'm even doing TikTok now. Can you believe it? 72 years old.
All right.
No better time. No better time.
No
That's
better
fantastic.
time, right?
Yeah. Doug, thank you so much for
Okay,
joining us.
Lynn.
We wrote that up
Thank
for
you.
We'll share all of your information in the show notes, and we'll have you back on soon. Thanks so much.
Absolutely. You bet. Thank you.
Bye-bye.
You know, there's so much, there's so many resources available for self-represented litigants, people who find themselves in these difficult situations. I absolutely agree that litigation is your last course of action. Even while you're litigating, I absolutely, value Doug's advice to get yourself that parallel mediation track as soon as possible, even if only to learn the opponent's positions. Doesn't mean you have to leave the battlefield necessarily, right? But you can at least learn what's going on in their minds. And so some great wisdom there that I'm sure is also covered in Kenn Goldblatt's guidance in the Civil Litigator's Handbook. There's so many good resources.
Yes, absolutely.
Don't have to be, and of course, I want to throw Courtroom 5 in there as well. Don't have to go it alone. There's lots of help available for people who find themselves in these situations. Well, that's all we have for you today. Thanks to both our guests, Kenn Goldblatt and Doug Noll. Looking forward to seeing them both again, and looking forward to seeing our audience again as well. That's all we have for you today. We will see you tomorrow. Thanks, everyone.
Are you feeling beleaguered, angry, or afraid, as if things are spinning out of control and you're powerless to stop them? It's easy to just let things slide and hope they don't get worse. But they often do get worse. The thing is, you're not powerless. Our courts belong to us, and their purpose is to give power to the powerless. Don't let your grievances pile up without redressing them. You can handle this in court. Or, if someone takes you to court, you can take them to school.